Solicitors and Haven Insurance Company.
Yes, it was.
Please, Your Lordship, my Lords. In this appeal, I appear with my learned friends, Mr. Jamie Carpenter and Mr. James Wibberley, for the appellants, whom I call Haven, and my learned friends, Mr. Jonathan Crowe, Ms. Leslie Anderson, and Mr. Martin Budworth, appear for the respondents, whom I will call Edmondson.
This case is obviously taken extremely seriously on both sides.
My lady, it is, and you may rest assured it's not all about £12,000.
We didn't think it was.
No. Lady, the Law Society of England and Wales is the intervener, by permission granted on the 17th of January, intervenes by written submissions from Mr. David Holland, QC, supported by a witness statement from Mr. David Marshall, the immediate past chair of the Law Society's Civil Justice Committee and a former president of the Association of Personal Injury Lawyers. His witness statement was permitted by order of the Court de Beniesse, but I should say that I don't take any objection to that witness statement being before the Court.
Thank you, that's very helpful.
Lady, this case concerns the right of a solicitor to seek the equitable intervention of the Court to secure the payment of fixed costs allegedly due under the pre-action protocol for low-value personal injury claims in road traffic accidents, which I shall call the protocol, against an insurer in circumstances where the insurer has settled the claims of the solicitor's clients, I think we both call the RTA claimants, directly with those RTA claimants, after the solicitor has served a claim notification form on behalf of each of those RTA claimants, and those are called CNFs in the shorthand, which have been acknowledged by the insurers in each case, but in respect of which neither party has taken any further action in accordance with the protocol before the direct settlement. My Lady Haven argues that in finding that the Court could grant equitable intervention in such circumstances, the Court of Appeal wrongly extended the principle of equitable intervention well beyond its previous limits and in conflict with the authorities, with principle, and with considerations of policy. Indeed, we would go further and submit that the decision of the Court of Appeal did not merely extend the principle of equitable intervention, but it purported to establish an entirely new basis for intervention, independent of any existing claim by the solicitor to be paid costs by a client. Edmondson accepts, as did the Court of Appeal, that in granting it relief, the Court of Appeal was indeed extending the equitable intervention principle, enunciated and explained in 2013 by Sir Stephen Sedley's judgment in the Court of Appeal in the leading case of Khan's solicitors against Chefuntwe. But Edmondson argues that equity is sufficiently flexible to accommodate this extension and that it should do so. Lady, that brings me to our first submission, which is that there can be no solicitor's lien at law or in equity unless the solicitor has an established right to recover his costs from his client. In essence, at the heart of Edmondson's argument is the proposition that equitable intervention is available to a solicitor, even where the solicitor has no such established right. Edmondson argues, though we will submit that the Court of Appeal did not go this far, that the concept of an equitable lien is broad enough and flexible enough to permit intervention without such a right. Edmondson goes further and says that equitable intervention is available in any case where, in the Court's view, a solicitor has an interest of whatever nature that the Court ought in equity to protect.
Is this a remedy that equity will afford to solicitors and nobody else?
Well, there's a case saying it ought to be afforded to barristers as well, but it was not afforded to insurers in that case, which is a recent case at the end of last year. Edmondson's argument, we say, betrays a confusion between entitlement, or a legal right, and an expectation. And we say that that confusion runs through the whole of Edmondson's argument. And it's summarized at paragraph 3.1 of Edmondson's case, where Edmondson argues that, and I quote, the jurisdiction is also, and should be, capable of operating in any situation where the solicitor has a sufficiently certain and legitimate expectation of payment, irrespective of whether that expectation is based on an enforceable contract of retainer with his client. And it is our submission in response to that Edmondson's written case insufficiently and inaccurately articulates and defines what an equitable lien is, and it fails to acknowledge that a solicitor's right to recover costs from his client is a necessary precondition for the imposition of an equitable lien. Lady, in our submission, the starting point that underpins this jurisdiction is that a solicitor with a right to recover costs from his client has a retaining or possessory lien as a matter of common law over funds that come into his hands. So if he has the money, he has a right to costs, he has a lien over the money. And that operates as security for those costs. So that as the Lord Chief Justice Lord Kenyon put it in Reed and Dupper, which is in our written case, paragraph 8, and the reference for your note is MS 450. It's A2, Authorities 2, tab 34. A party should not run away with the fruits of the cause without satisfying the legal demands of his attorney, by whose industry, and in many instances at whose expense, those fruits are obtained. And we stress the word, the legal demands of his attorney. And it follows from that, and from all the cases, that of its nature, that lien is limited to the amount of the costs to which the solicitor has a contractual right.
That's a common law lien.
That's a common law lien. And we say that that persists into an equitable lien. And the reason we say that is that what equity is doing is merely granting an ability to treat a fund as available, even if it hasn't come into the solicitor's hands. But that is still a security right, and the security is limited to the debt.
So you accept that there's an extension in equity of the common law principle to funds that are not in the solicitor's hands?
Oh, indeed. That is the fundamental extension that an equitable lien grants, is that
So it's not in the client's hands.
it's not in the solicitor's hands, and it can be stopped on its way to the client, and it can be stopped in terms of a debt.
It's a slightly unusual concept of lien, isn't it? Even in equity, if it is a lien over, it's really a charge, isn't it?
Yes, it is an equitable charge, but it also explains the point my Lord Sumption makes is important in explaining why it is that in a number of the cases the term equitable lien is questioned, and the courts have said an equitable lien really means no more than the right to apply for equitable interference to support a solicitor's right to his costs. The point we're making is that it is dependent on that right to the costs being established before equity will act.
So how would it rank in an insolvency? Suppose there are other creditors. Would the equitable charge or lien or whatever you call it would the chargee or lienee take priority over a general creditor?
What generally happens in cases of insolvency is that the solicitor will apply for a charging order under the Solicitors Act, and that charge takes priority.
But apart from the statutory
right,
he's postponed, is he? Or at least he ranks with the general creditors. Is that right?
My lady, that particular point I don't think has been determined.
Right.
But
it might be rather important if we're going to decide what the nature of this interest is.
It's certainly equated only with the right to seek the interference of the court. Once the interference of the court is granted, so that there is an order that effectively for payment, then that must take priority. Before that, my answer would be that it doesn't take priority.
Okay.
My lady, in this case, we say that it is significant that the sums awarded to Edmondson, which were effectively £2,070.50 each, being their fixed costs, disbursements and VAT, plus the ATE premiums, and those were fixed costs that they might have expected to recover at the end of a protocol process, in fact exceeded the settlements agreed and paid by Haven to the RTA claimants. And that's the case in every case except for Mr. Tonkin, who was lucky enough to secure £2,350 in settlement, partly because he was a part-time cage fighter. Mr. Granell received £1,900 and the other four £2,000 each. But in each case, the award of the Court of Appeal exceeded the amounts in settlement. So they didn't treat it, that award didn't treat it as a lien at all, because the amounts of the settlement were overtopped by the amounts of the recovery. In summary, we say that where a fund has arisen as a result of the solicitor's chargeable work, and only for that amount, equity will act to grant the solicitor security fees over the fund as if it had been in his possession. And the point that I'm making is that an equitable lien is no less a security for a costs debt than the solicitor's possessory lien in law. And we say that the right to cost is no less a precondition for the existence of an equitable lien than it is for a possessory lien in law. And my lady, to summarise the point at issue, it's essentially the argument between our understanding in paragraph 66 of our case, which is at MS 1115, Edmondson should not be able to achieve more in reliance upon the court's equitable jurisdiction than it could achieve as a matter of law. The jurisdiction is necessarily limited to providing ancillary protection to existing rights. It does not extend to the creation of new rights which Edmondson did not enjoy and which on the facts did not arise. And Edmondson's argument that equity should intervene if it is just to do so, which is at paragraph 3.2 of its summary of its case at MS 1135. And if I can invite my lady and your lordships to read through that paragraph. We say that it is a matter of principle and not a coincidence that in every one of the cases where the jurisdiction has been successfully invoked, the solicitor claiming intervention has had a right to recover costs from his client. And we invite you to reject the view which Edmondson advances in paragraphs 27 and 30 of its case, that the case law does not support a narrow approach of insisting that a lien is ancillary to a contractual right. We say that the solicitor's legitimate interest, and that is the phrase used by the Court of Appeal in Cannes, is exactly his interest in being paid what he is due for his costs. And again, using the words from Cannes, where the judgment talks of a claim on funds, a solicitor cannot have a claim on funds unless he has a contractual right to his costs. My lady, if I may test the point by asking, what would have happened if Haven had paid the settlement monies to Edmondson? We say that had that happened, Edmondson would not have had a lawful right to deduct its costs from those settlement monies. And the reason for that would be that no costs were due from the client to Edmondson. And if that is right, and we say it is right beyond peradventure, what Edmondson is therefore seeking, and what the Court of Appeal in effect ordered, was that Haven's settlements with the RTA claimants should be rewritten to provide for costs, even though it was quite clear that they did not provide for costs when the settlements were agreed. We say, and we'll come to this a little later, that those settlements were bona fide compromises and the court cannot interfere with them. Nor can the court create a new liability of the clients to the solicitor, which doesn't otherwise exist. My lady, in our written case, we set out a history of the principal cases on which we rely, and we rely on all those cases for all of the propositions that I've advanced. And if I can summarize them very quickly, the first is that the lien is a lien for the solicitor's bill of costs. The second is that the solicitor's lien at common law is a retaining lien, which affords security for those costs over money that comes into the solicitor's hands, or as Lord Mansfield said in Welsh and Whole, which is the classic statement of the jurisdiction, is stopped in transitu. So that is a form of legal lien. It follows that it's limited in extent to the amount of the bill, which Lord Mansfield says, the amount of the bill, which Lord Mansfield says specifically. And we say the right to seek the equitable intervention of the court is an ancillary right in equity to afford the solicitor the protection of the lien, even where the funds not come into his hands. But we say there does have to be a fund, and that is what is meant by an equitable lien. An equitable lien operates just as a common lien does, as a security for the solicitor's rights to costs. It's a secondary right and is dependent upon the existence of the primary right to costs. My lady, in Welsh and Whole, I do stress the last line of Lord Mansfield's classic statement of the rule, which I needn't invite you to turn up, but it's at tab A3, 43, MS 1102. And Lord Mansfield says at the end of his statement, but I think we cannot go beyond these limits. The passage is the passage starting, an attorney has a lien on the money regarded.
You've given us the reference to the citation in your case rather than to the actual case.
I'm so sorry, 535.
Thank you.
My lady, may I take you briefly to the case of Sullivan and Pearson ex parte Morrison in 1868. That is at the volume 3 of the Authorities Bundle, tab 40.
Page?
It's page 508 in the electronic bundle. The court will see that the head note shows that the facts are relatively similar to the facts in this case. An impecunious plaintiff who really wanted the money, a compromise achieved directly between the parties, where the outcome of the litigation was uncertain. And if I can take you to page 511 first in the judgment of Mr. Justice Blackburn. Halfway down the page. There is no doubt, he says in the second sentence, at all, that where an attorney has by his labour or his money obtained a judgment for his client, he has a lien on the proceeds of such judgment and is entitled to have its proceeds pass through his hands. The lien does not amount to an equitable assignment of the proceeds of the judgment, but it is yet protected by the court. Where there has been an actual judgment, whether there's been an actual judgment, or whether the fruits of the litigation have been obtained without a judgment, if an arrangement is made to prevent the attorney from reaping the benefit of his lien, the court may set aside such an arrangement or may force the parties who've so deprived the attorney to pay the costs for which the attorney had the lien. It's not necessary to define what would be a proper case for the interference of the court. And we say we derive from that the preconditions of that, even if the court can thereafter, once those conditions are met and there is a lien, act flexibly. And over the page in the judgment, at 513 in the electronic bundle, it was therefore doubtful whether the litigation would in the end be successful. That's where it hadn't been concluded before the compromise. At the time of the compromise, it was far from being so. The case then seems to fall within that class of cases where the compromise is made while the litigation is going on and it has not reached a successful issue. The case was, in fact, in a stage of expense. There was no actual fraud. The plaintiff really wanted the money, and the defendant being sued by the pauper might well give £10 to save the expense of a new trial. It was not necessarily collusive. There'd been an order for a new trial in this case. This is an application to the equitable jurisdiction of the court. And when an arrangement is made to deprive an attorney of the fruits already obtained in the litigation, and thus to deprive him of all remuneration, this jurisdiction will be put in force. But this is not the case here. The attorney has no claim unless the law be that when litigation is once commenced by a pauper, the attorney has a right to insist on the action being continued to judgment. But this is not the law, and it would be more satisfactory if the attorneys relied rather upon their client's ability to pay them than upon the chance of obtaining their costs from the other side as the result of the litigation. We say the parallels are clear, and Mr. Justice Hayes agreed with Mr. Justice Blackburn's judgment. And we say also that the significance is that the court refused to find that there was a lien because there was a significant chance that no costs would ultimately be recovered if the case proceeded to judgment. The case of Mason and Mason in 1933, the reference for your note is tab 2 in volume 2 of the authorities. So 22 in volume 2 of the authorities. It's MS 288 is the passage that I need. And we say that this case reinforces the security for a right to recover costs. And the judgment is the judgment of the then Master of the Rolls, Lord Hammer. And he said this: the nature of the solicitor's lien is pointed out in the course of that case, and he was referring to a case called Mercer and Graves. It is merely a right to claim the equitable interference of the court, who may order that the judgment obtained by the solicitor's client do stand as security for her costs, and that payment of such an amount as will cover them, that's the limit of which I spoke, be made to the solicitor in the first instance. So money can be diverted, but it is subject to the limits that apply to a common law lien. My lady, in our written case, we also referred to passages in the judgment of Mr. Justice Scarman in the estate of full deceased, Authorities Bundle 1, Tab 8, and the passage on which we rely is at MS 58. Now, Edmondson rely on aspects of that case at paragraphs 9 and 10 of their written case, and the Law Society also rely on it, and they say it supports a broader equitable jurisdiction. And there are fairly long passages that it's necessary to read, so I'd invite you, if I may, to read the judgment of Mr. Justice Scarman, as he then was, from page MS 66E to MS 68G, and also 70D to G, in relation to the analogy with the Solicitors Act charge and the effect of that charge. And we say that Mason supports our propositions that the existence of a lien over costs payable by the client to the solicitor is a prerequisite to the court's jurisdiction, that the extent of the lien is limited to the amount of the costs in respect of which the solicitor has a legal right. My lady, Carnes, of course, is the modern statement of the full principles that apply as a result of the application of this jurisdiction. You will have read and been familiar with the conclusion at paragraph 33. It's at tab 17 in volume 1. And paragraph 33 is at MS page 219. In our judgment, the law is today, and in our view has been for fully 2 centuries, that the court will intervene to protect a solicitor's claim on funds recovered or due to be recovered by a client or former client, if A, the paying party is colluding with the client to cheat the solicitor of his fees, or B, the paying party is on notice that the other party's solicitor has a claim on the funds for outstanding fees. The form of protection ought to be preventive, but may in a proper case take the form of dual payment. And my lady, I say in parenthesis that a great deal is said in Edmondson's written case about the flexibility of equity. We accept that flexibility, but the flexibility is as to remedy. In other words, as to the way in which the court will give effect to an equitable lien. It doesn't alter the necessary prerequisites for the existence of the lien. My lady, may I say a word or two about the Solicitors Act? It's now Section 74, Section 73 of the Solicitors Act 74, which gives a statutory right to a charging order. It's discussed in our written case at paragraphs 22 to 27, and it appears for your record, but there is no need to look it up, at tab 52 in Authorities Bundle 2, MS 588. And we say that the Solicitors Act charge is similarly dependent on the solicitor's right to recover costs from his client, and the charge is only in respect of such costs. My lady, Edmondson's written case criticizes our description of the rights to a statutory charge as a codification of the solicitor's right to security to protect his lien. And we accept, of course, that an equitable lien may in some respects be broader. For instance, it can apply to the proceeds of an arbitration. It doesn't apply only to the proceeds of court proceedings, and liens may cover settlements. But the principles, we say, are the same, and the purpose of the statutory charge was, as we say in our written case, to ensure that a solicitor would have a charge on real property as well as on personal property, because there had been an earlier decision of the House of Lords I think called Shaw and Neal, which was to the contrary. And that led to the passage of the original Solicitors Act, which I think was 1860. My lady, this view is supported not only by what Mr. Justice Scarman said in Full's case, to which I referred, but also by the decision of Mr. Justice Farwell in the case of Bourne, which is tab 3 in volume 1, starts at MS 34, and at MS 36, Mr. Justice Farwell says this, and we say this is a complete answer to the criticism of our approach to this legislation. It is also contended, halfway down the page, that having regard to the winding up, I ought not now to give the applicants a charge under the statute. But though this application is under the statute, it is very material to consider whether, if I make a charging order, I'm therefore giving the applicants a new right, or merely enabling them more cheaply and speedily to enforce a right they already possess. Now, it is plain that they have a common law lien on the company's share of the funding court for the amount of their costs. It would be monstrous if this were not so, as the company would never have recovered the money without their exertions. It resembles the case of debenture holders who have to allow a liquidator's costs when they take the benefit of his exertions, and it's clear that justice calls for such a lien. Now, this common law lien has not been abrogated by the statute, Hames and Cooper, or affected by the winding up, and all I am really asked to do is to give the statutory charge in aid of the already existing common law lien, which is prior to any right of the official receiver or liquidator. So that at least is it's not an answer to Lord Sumption's question, because a common law lien, of course, takes priority. It doesn't answer the question of whether an equitable lien takes priority, but certainly a statutory lien does. And my lords, this analysis is supported by Cordery on Solicitors. And it's at the last page, which is 701 of volume 3 of the Authorities Bundle at tab 63. This is the 1878 edition of Cordery's, which I think was the first one after the 1860 Act.
Sorry, what was the electronic page reference?
The electronic page is 701.
Thank you.
A solicitor is entitled under the common law and by statute to a particular lien which is capable of being actively enforced on a fund or judgment recovered by his exertions, but only for the amount of costs of recovery or those immediately incidental thereto. The common law lien is enforced by the court notwithstanding that the solicitor's claim is barred under the statute of limitations, but it doesn't attach to real estate recovered by the solicitor. Under the Solicitors Act, 1860, Section 28, the lien is extended as well to real as personal property, but is conditional on a declaration to be made by the court on the solicitor's application is subject to the operation of the statute of limitations. The recognition of the lien by statute has not abrogated its existence in common law, and before dealing specifically with the decisions under the statute, it may well be to refer to those on the common law, the principles of which are equally applicable to the lien under the statute, except so far as they are expressly modified by its language. The lien attaches only to the actual balance coming to the client after adjusting the equities between the parties. Though we say it is possible to draw a very close parallel between the Solicitors Act charge and the lien, both at equity and common law. Lady, I have an ancillary submission as my second submission at this stage on freedom of contract. And at paragraphs 28 to 31 of our written case, we argue that the equitable jurisdiction is not intended to interfere with the freedom of parties to disputes to compromise them directly with each other, provided, first, that the compromise is a bona fide settlement rather than a collusive agreement made with the object of defeating the solicitor's lien. All the cases in which compromises have been considered, from Welsh and Hull onwards, stress the entitlement of parties to settle proceedings by compromise without the involvement of solicitors. My lords, I'd add in parenthesis that in Megadichian and Lightbound, which is the first volume of Authorities, tab 23, at page 292 in the electronic bundle, in 1917, the Court of Appeal decided that a lien would not exist in respect of the fruits of a compromise where no litigation has been commenced. But while that was certainly a limit on the court's jurisdiction at that stage, we've not argued that this court should follow that decision in this litigation, and we don't seek to so to argue now. My lady, we do rely, however, on the passages that we've cited in our written case at 28 to 30 from Brunston and Allard in 1859. That is tab 5 in volume 1 of the Authorities bundle. And it's MS 44 are the passages that we rely on. They're passages for Lord Campbell, the Lord Chief Justice, and Mr. Justice Crompton. And we say that all these judgments in that case support the rights of parties to compromise disputes directly without the involvement of their solicitors, provided that the compromise is bona fide and not a collusive agreement for the purpose of defeating the solicitor's lien. And in Carnes, the Court of Appeal by Sir Stephen Sedley said this at paragraph 27, reference being MS 218 in tab 17 of volume 1. The ability of a client to dismiss his lawyers and continue in person is undoubted. Mr. Chifuntwe was accordingly free, in principle, both to compromise his claim for costs and to take payment of the agreed sum himself. My lady, that proposition was expressly accepted by the Court of Appeal in this case at paragraph 32 of the Court of Appeal's judgment, and we will turn to the significance of that a little later. And my lady, I make a further point about this case in particular. It is worth remembering that what Edmondson claim in these proceedings is not the costs that they could have recovered from their clients, the RTA claimants, but for the client care letter, the costs which the RTA claimants might have been liable to pay Edmondson would be Edmondson's basic charges, disbursements, and a success fee. And if I could invite you to look in the appendix at MS page 1280, my lady, halfway down the page under the heading Paying Us, if you win your claim, you pay our basic charges, our disbursements, and a success fee. You're entitled to seek recovery from your opponent of part or all of our basic charges, our disbursements, a success fee, and insurance premium, as set out in the document what you need to know about a CFA. And that document, for reference, and it's agreed, although it's slightly differently entitled, is the document over the page at 1282, the Law Society document, and it is common ground that that document was incorporated into the contract. But far from claiming those fees, which they, but for the client care letter, they would say they would be able to claim on winning. What they claim is the stage 1 and stage 2 fixed costs under CPR Part 45 that they say they might have expected to be paid had the case proceeded to settlement under the protocol. And those sums, we say this is important, could never have been due from the RTA claimants to Edmondson. They could only have been due from the RTA claimants, from Haven to the RTA claimants.
I'm not sure I saw a reference to this point in the Court of Appeal judgments. Was this point raised?
It was there in the discussion on the pleadings. It wasn't in the judgments, but it is an important point. And you'll see, I'll take you to the pleadings in a moment. But what they're claiming is effectively damages to represent the costs that Edmondson might have expected to recover from Haven had the case been settled in accordance with the procedures of the protocol. But we say that if any lien applied, it would have attached to costs recoverable by Edmondson against its clients and not to fixed costs assessed by reference to the protocol. And if I can invite you to the pleadings, I think the Appendix Part 2 is not in the electronic bundle. If I can take you to page 122 in Part 2 of the appendix.
You say it's not in the electronic bundle?
Appendix Part 2.
Well, it should be.
Well, I certainly asked for all the documents to be, but...
Well, everything to which you want us to pay any attention at all should be provided electronically.
The fact you haven't got the electronic numbers doesn't necessarily mean, in relation to Appendix Part 2, that there are no electronic numbers.
We'll find out.
We do have Part 2 of the appendix on the electronic file.
Uh-huh.
Which tab is it?
It's tab 23.
Tab 23. That's the re-amended pleading.
Yes.
Yeah, we've got it.
I am sorry, my lady.
It's all right. It's at
Yes.
1332.
I asked for all the documents in the...
1332?
paper
Yes, no,
bundles,
they are.
in the electronic
Well,
bundles.
they are in the electronic bundles. It's just you don't have them.
I also asked for the numbers to be on them, but that hasn't happened.
Yes.
I am sorry.
Well, I was merely raising the question because it's not as if this is a case at which large sums of money have not been thrown.
It's true.
So we do expect the court's practice directions to be provided.
I have no explanation as to why it's not there.
But it doesn't matter. They are there as long as you have
at
people
any
on
rate,
either
can I
side
take
who
you-
can give you the numbers.
Can I take you to paragraph 15.1? Which is in the paper bundle at 122.
And it's MS 1335.
And what they allege is further alternatively, in settling with the clients in the manner in which it did, the defendant breached the provisions of the protocol in that, and then it sets out paragraph 737, to which I'll come in detail, and 740 requires that on any settlement the defendant must pay the agreed damages, stage 1 and 2 costs, disbursements, and success fee. And then 2 pages on, at paragraph 17 and 18, by reason of the defendants, if we then go on 3 lines, and or equitable interference, the claimant has suffered loss and damage being the costs it would have received if the cases were settled via the protocol, pursuant to the protocol as they should have been, and or simply by involving the claimant as appointed representative, which would have happened but for the defendant's tortious acts or equitable wrongdoing. And then at 18, the claimant contends that its loss is the costs it would have received in respect of the 6 clients. And the 2,400 is £400 stage 1 costs by 6, £800 stage 2 costs by 6 is the 4,800, £150 by 6, which is 12.5% for success fees, VAT on that, and disbursements of 2,703 altogether for the 6. So Edmondson's case was not put upon the basis of an entitlement to costs against its clients and a lien for those costs, but was put on the basis that it claimed damages, allegedly for breach of the protocol, in the amount of the fixed costs which it said it would have earned had the case, and only had the case, continued to a successful conclusion in accordance with the procedures of the protocol. My lady, that brings me to my third submission.
Just before you move on,
Lord, yes.
you described the entitlement under the CFA, ignoring the client care letter, as being cost, disbursement and success fee. Do you say the disbursements or the success fee would have been different under the CFA than that which is awarded which is claimed under the protocol?
I think not.
So
12.5% was the success fee which
so why would
they were recovering.
And why are the cost figures different from that which would have been claimable under the CFA but for the client care letter?
Because those would have been payable on an hourly rate basis.
That's set out in the CFA, is it?
That's set out. Sorry.
I mean, don't take time out of your main submissions if you want, or somebody just wants to provide a note.
That's at page 72. Mr. Carpenter reminds me that it's not entirely clear nor entirely happy because the basic costs are defined. They're defined, said to be as fixed by the civil procedure rules, but they do not match the figures that they should have been.
But surely the costs in the protocol are fixed by the civil procedure rules.
Yes.
So why is there any difference between what they're claiming here and what they would have been entitled to under the CFA?
Because what it says here is if your claim is settled, this is at MS page 1284. If your claim is settled before proceedings are issued for less than £10,000, our basic costs will be £800, as opposed to £1,200, plus 20% of the damages agreed up to £5,000, and 15% of the damages agreed between £5,000 and £10,000. If you live in London, those costs will be increased by 12.5%.
Thank you.
So they don't match. But it then says these costs are fixed by the civil procedure rules. They don't match the costs mixed by the civil procedure rules either.
Sorry, Lord Marks, where are you reading from?
I'm reading from the top of 1284 under road traffic
Thank you.
accidents.
Oh, yes, thank you.
And the point that I make in answer to Lord Briggs' question, even though I was wrong to talk about an hourly rate because that's not there, I'll look and find out where the reference is later, is that the protocol only fixes costs inter partes. So the protocol fixes what Haven will pay the RTA claimants. It does not fix or purport to fix what Edmondson, the solicitors, can recover from the RTA claimants, their clients.
Yep, that makes sense.
I come then to my third submission, which is that Edmondson had no right to recover costs from the RTA claimants in this case. And that, as the court will note, is the first part of issue 1 in the statement of facts and issues. My lady, I start from the position that there were concurrent findings of the trial judge and the Court of Appeal to that effect. His Honour Judge Jarman at trial made that finding at paragraphs 10 to 12 of his judgment, which is at MS 1234. And my Lord, Lord Justice Lloyd Jones, as he then was, put it in the same way at paragraphs 17 and 18, and then at 30 of the Court of Appeal's judgment, and that's page 1223. My lady, the Court of Appeal said that paragraph 30 of the Court of Appeal judgment was not the end of the matter. And it may be helpful just now to look at those two paragraphs of the Court of Appeal judgment. So paragraph 30, if I can invite you to read through that, no doubt already familiar to you. And the Court of Appeal went on at 31. This is not the end of the matter, however, and my lady, bluntly we say it should have been. While Edmondson has no right to recover fees from its clients, I consider that in the normal course of events, Edmondson would have an entitlement to recover the fixed costs and other sums payable under the protocol scheme. This is an entitlement in Edmondson itself, or alternatively in the light of the contractual arrangement between Edmondson and its clients referred to at paragraph 22 above, an entitlement to bring proceedings in the name of the clients to recover those sums. And, my lady, much of what I say for the rest of my submissions after dealing with this question of whether the decision that there was no direct entitlement to costs will be concerned with that part of paragraph 31. But what we say, coming back to the finding that there was no right to costs, first of all, I should insert that Edmondson wishes to maintain the argument that it had a contractual right to recover its costs from the RTA claimants, because it says the CFA should be read together with the Law Society guidance, but independently of the client care letter. And in my learned friend's written case, they discuss the need to obtain permission to run that argument. And I should say that whether or not Mr. Crowe and his colleagues need permission, we have no objection to their running that argument. But, my lady, we do say very firmly that the client care letter has to be considered as part of the contractual documents. That was described by the judge as common ground at first instance. Edmondson conceded it, and it wasn't just in Mr. Edmondson's evidence, though he was absolutely clear about it. There's no need to turn up the references, and I will have the electronic references after lunch. but it's page 195 to 196 in Appendix 2. But it was never in dispute, because he was absolutely clear that this was the client care letter was part of the contract. In paragraph 44 of the Statement of Facts and Issues, at MS 1092, so it's at 1093. In its appeal, that is to the Court of Appeal, Edmondson did not seek to challenge the finding recorded at paragraph 42 above directly. And the finding is at 42. Additionally, the judge found that the provisions of the client care letter, which limited the RTA claimant's liability to Edmondson to those costs recovered from Haven, meant that Edmondson did not have a claim for costs against the RTA claimants. This, in turn, meant that there was nothing in respect of which Edmondson could assert a lien. And we say Edmondson was right not to challenge that finding, because there was strong authority of the Court of Appeal that the client care letter was part of the contractual documents. In our written case at paragraphs 40 to 43, we set out the relevant passages from the judgment of Lord Justice Waller, with which Lord Justice Hughes agreed, from the Court of Appeal's decision in the case of Jones against Wrexham, tab 16 in Authorities Bundle 1, at MS 186, and the passages start at 195 and following. And, my lady, I do at some stage invite you and invite the court to look at that judgment, because in particular, without wishing to read it now, it's worth noting that the terms of the client care letter in that case, which are set out in paragraph 32 of Lord Justice Waller's judgment, were, if anything, less clear than the relevant passage in the letter in this case. But there was certainly nothing to distinguish Jones and Wrexham in Edmondson's favour. And the ratio, really, of that case is that in looking at the contractual documents, the whole package, to use the phrase used, has to be considered, and the client care letter was an integral part of it. Edmondson is wrong to say, as it does at paragraph 58.2 of its case, that a contract of retainer had already been agreed before the client care letter was sent in this case, because they refer to thank you for your instructions and so forth. And the reason they're plainly wrong to say that is that by section 58 of the Courts and Legal Services Act 1990, as more recently amended, a CFA can only be agreed in writing. And on the facts, the CFA was sent to the RTA claimants together with the client care letter, and one would expect the client care letter to have been read first by the RTA claimants, that is before the CFA and the Law Society guidance, because it plainly reads as a covering letter. And we submit that it would be extraordinary if a solicitor could be heard to say that in the absence, that in his letter of advice as to the meaning of his retainer, concluded in a document in the same envelope as the letter of advice, to say that that letter should be ignored in construing what the retainer actually meant. And we say that the judge and the Court of Appeal were plainly right as to the effect of the client care letter, and both courts held that the use of the phrase "for the avoidance of doubt" used in the client care letter and it's at page MS 1277. Halfway down the page, For the avoidance of any doubt, if you win your case, I will be able to recover our disbursements, basic costs, and the success fee from your opponent. You are responsible for our fees and expenses only to the extent that these are recovered from the losing side. This means that if you win, you pay nothing.
Okay, but you are responsible, Lord Marks. You, Mr. Granell, are responsible.
That cannot be read in isolation from only to the extent that
No.
these are recovered from the losing side.
Read it all. Yes.
You will only have to pay anything, or you will only be responsible for anything, to the extent that these are recovered from the losing side. In other words, if you win, you pay nothing.
Doesn't it make a distinction between responsibility for the fees, which is set out in the CFA, and the practical reality that there will be nothing that you'll actually have to put your pocket in and pay, because that for which you were responsible will be getting from the other side?
My Lord, the effect of this is that this is a client care letter going to a lay client. The effect is this, you will pay nothing. If you lose, you pay nothing. And if you win, you pay nothing, because we will get the costs from the other side. And the use of the words only to the extent that these are recovered from the losing side qualifies any responsibility, because it is in effect saying, on its natural construction, not just to a lay person, but on its natural construction, it is removing any responsibility.
Why use the expression at all, you're responsible?
The reason is, and I'm indebted to Mr. Carpenter for this point, that the words "you are responsible" are necessary to satisfy the indemnity principle. In other words, in order to achieve recoverability, some element of responsibility is necessary in order to recover from the other side.
Well, that's also true on your submissions about the lien, isn't it? That the lien, the ability to recover by the exercise of the lien from the other side, depends upon there being a responsibility of the client for the fees.
Yes, but it's not contingent in the case of a lien on actual recovery. The point about this is that it is what is known as a CFA light, which means pay nothing, win or lose. In the case of a lien on costs that you're going to recover from the other side, where you have an actual responsibility to your solicitor that results from his retainer, recovery from the other side is entirely uncertain. And your responsibility for your costs exists irrespective of the lien. What the lien does is give the solicitor a right to the costs that come into the hands of the client or that are payable to the client, that's the equitable extension, in order to satisfy that responsibility. And if it cannot be satisfied, the solicitor will still look for his costs. The CFA light, there is absolutely no corresponding responsibility, because the contingency is recovery from the other side. That is actual recovery if we get the money. And that is explained in the last sentence. This means that if you win, you pay nothing. So I quite understand the reason for the question because of the use of the word responsible. But I also invoke Mr. Carpenter's response, which is that the words responsible are necessary in order to satisfy the indemnity principle.
Well, you were at pains to point out that this was a letter to a lay client.
Yes.
I rather doubt that a lay client would pick up that slightly ingenious response.
Well, nor would he pick up that the word responsible could impose upon him a responsibility to pay any costs, in the light of the fact that the very next sentence says, this means that if you win, you pay nothing. So that we submit that the...
So the submission...
I'm struggling with the notion that responsibility which lies at the heart of the indemnity principle is any different from the responsibility that lies at the heart of the right to exercise a lien. The combination of a responsibility under the indemnity principle to pay is what enables, on your submission, the lien to be enforced, and is the mechanism whereby the second half of the first sentence of this passage, I will be able to recover our disbursements, etc., from your opponent, operates, isn't it? An order for costs is still an order for costs after success, payable ultimately to the claimant, but the solicitor recovers by the exercise of his lien.
My lord, that's right up to a point, but there is an artificiality about it, because the question as to who pays the costs is answered by this letter, as both the trial judge and the Court of Appeal found, because under no circumstances will the client pay anything. So that the concept of responsibility on the client's part simply doesn't exist in real terms. My lord,
Well, isn't your
raises-
submission that
I'm so sorry.
the responsibility does exist, but there's an agreement that it shall be discharged exclusively by recourse to proceeds of victory,
My lord, exclusively and conditionally,
obviously on their being such.
yes. Because if there is no recovery, even if there is a right to recovery, there is no responsibility.
Yes.
And that's what this would mean to the lay client, and that's what the courts below found.
Well, it's really...
In answer to my...
Your submission's got to be, hasn't it, if you're going to give full effect to the responsibility, that there is an agreement here as to the only circumstances in which the client's liability will be enforced against him directly.
And the agreement is that they will not be enforced, yes.
Exactly.
Yes. My lords, the point is that this is the CFA light, which is regarded as an absolute no-win, no-lose, no-win, no fee, and no-lose, no fee. So there is no fee in any event. In answer to my Lord Briggs's question, I accept that there is a certain amount of artificiality in the use of the word responsibility here. And I also accept that it is odd in the context of the indemnity principle. But since we now have authority that the indemnity principle does not apply in the case of recovery of fixed costs under the protocol, it's perhaps an academic question only. What we say is that there is the reality is that there is no responsibility on the client to pay any costs in any circumstances. And in the context of our principal submissions, the question is as to whether the solicitor has a right to claim costs. And never mind whether there is any expression that uses the word responsibility. There is no right to claim costs in the solicitor against his client in the case of a CFA life. And if there is no right to claim costs, there is nothing over which the lien can operate.
So, how do you explain what underlies the solicitor's assertion to the client is that if you win, I will be able to recover our disbursements, basic costs, and the success fee from your opponent, other than by reference to a lien or charge? I mean, you can give different examples for your answer. I mean, we can start with what if you go to trial?
Yes.
Say it goes to a stage 3.
It goes to a stage
under
3.
the protocol, and
yes.
you get a judgment. Or liability is an issue and you win at trial. But
yes.
let's take the more typical example of a stage 3.
Yes. Well, in those circumstances, there is no doubt that under the protocol, the traditional rule that the client recovers an order for costs and the client is entitled to the costs, applies.
So how does the solicitor recover on the opponent?
The liability is triggered because the order for costs is made.
Yes.
And the liability for costs I accept is...
But the
is
creditor
to the
under that order is the
creditor
client.
is the client. I quite accept that. And the solicitor takes the money, and I quite accept that. And that operates in the same... In exactly
That must be by the right to enforce a lien or exercise a charge,
yes, I accept that.
which normally gives rise to no dispute because the money is paid over to the solicitors.
Yes, I accept that that's right.
So on this client care letter analysis, the solicitors are saying to the client, you have a responsibility, that gives us a lien, and the combination of the responsibility and the lien is that you won't have to put your hand in your pocket, isn't he? Isn't that what the solicitor is saying to the client? Spelling it all out if the client wants to understand the mechanics.
The solicitor is certainly saying to the client, you will pay nothing, and the reason for that is that there will be a recovery, and I accept that that is a recovery in the client's name, and we will take the funds. And that operates in exactly the same way as a lien. I accept that.
Yeah.
He gets the funds. But we say the effect of the CFA light is to give the client no liability to the solicitors in any circumstances. And that's what it makes it, a CFA light. That's what the phrase means, is no payment, win or lose. My Lords, if I can move on to Mr. Marshall's evidence, which is at page 15 of his witness statement. The reference is MS 790, and I need to turn it up. He makes the point that CFA lights are made lawful by the 2003 regulations, and in his words, those regulations allowed solicitors to market clearly to clients that they would pay nothing if they lost and nothing if they won, as the only costs charged would be those recovered from the opponent. And he says it was obviously desirable for solicitors to be able to make such charging arrangements transparent to the public. Yet Edmondson contends, nevertheless, the RTA claimants are liable to Edmondson for their costs, even in the event of recovery. And that's the point that I make, in spite of the analysis that Lord Briggs has just put to me and that we have accepted, that the way the liability is recovered is by way of a charge on the costs recovered by the claimant in favour of the solicitor. But what we say is that there is never going to be any liability in the clients for the solicitor's costs.
And it follows, therefore, doesn't it, under a CFA light, that even if the solicitors do take, on your submissions, even if the solicitors take the case to court and win, and the insurers pay the money directly over to the solicitors, they have no right to take their costs and disbursements and success fee out of those monies, and they must hand it entire to the client under a CFA light which contains a CFA and a client care letter in these terms. Because you say there is no lien or charge.
They're entitled to take the costs they recover, the fixed costs they recover, or the costs they recover.
Unless they have a lien. I thought you just accepted that it was because of their lien or charge that they had that entitlement.
My Lord, I accept that to the extent that the costs are recovered, there is a liability. That's at the heart of this. And at that stage, there is a lien.
Well, the CFA says so, doesn't it?
Yes.
So the CFA says, if you get costs...
If you get
we
costs, I get them.
And the letter says, if you don't otherwise, you don't pay anything.
Yes.
Yep.
So I think really the solution to the conundrum put to me by Lord Briggs, and I quite understand the analysis, and I accept that analysis, But the point is that the lien can only arise at the stage of recovery, because only at that stage is there anything for the lien to bite on. And it comes back to my original submissions that there has to be a fund. And until recovery, there is no fund. My lady, Mr. Marshall also makes the point at paragraph 16 of his witness statement that success fees are now not recoverable, so that under the new arrangement, solicitors may charge them to clients out of their damages. But they may wish to keep CFA lights truly cost-free for marketing reasons, and in that case they may wish to forego the right to deduct success fees. And what he says at the end of that paragraph in MS 791 is in both cases, the CFA package will need provisions analogous to those set out in the Crown Care letter in the current appeal. And that makes a point on which we rely in this appeal, which is that solicitors can always draft their CFA light contracts so as to incorporate protection for themselves. My lady, may we again test Edmondson's case here with a question. What would happen if Edmondson tried to sue a client for unpaid fees which hadn't been recovered from the insurers? And we say that Edmondson would have been met with not just a contractual defence based on the client care letter, but also with an alternative defence of promissory estoppel based on the promise, if you win, you pay nothing.
Or does it mean if you win, you pay nothing out of your own pocket?
Yes. It means if you win, you pay nothing. We will recover from the other side. At that stage, that will be an order in your favour. We will have, on Lord Briggs' analysis, which I accept, a lien over the amount recovered, because that is a fund on which a lien can exist.
If you win, you will be paid costs, and we are entitled to them, but you have to pay nothing out of your own pocket.
My lord, yes. And including out of the damage. All they get is a right to take the costs on an order for costs or on automatic fixed costs. And they only get it at that stage. So the important point in my Lord Wilson's sentence is will be entitled to take the money at that stage. Because the lien on Lord Briggs' analysis only comes into effect when the recovery takes place. My lord, my lady, if I can move on to our fourth submission, which is that Edmondson had no legal entitlement to recover costs under the protocol, which is in issue 2 in the statement. And we say absolutely no entitlement in Edmondson can be said to arise under the protocol. All that arises is a mere contingent expectation. And we say that an expectation, even a well-founded one, as there was not in this case, does not amount to an entitlement. Edmondson's analysis depends on, first, their contention that returning the acknowledgement of the CNF amounts to an agreement to be bound by the terms of the protocol. Secondly, the proposition that they advance, that the Court of Appeal put forward, that in the normal course of events, Edmondson would have an entitlement to recover the fixed costs and other sums payable under the protocol scheme, and that's in paragraph 31. And thirdly, their contention that if Haven were bound by the terms of the protocol, that gave Edmondson an entitlement to recover fees from Haven. And my lady, we say that analysis is seriously flawed in 6 ways. First, we say that Haven's acknowledgement of the CNF had no binding contractual force requiring Haven thenceforth to comply with the protocol. Secondly, we say that because the protocol is not mandatory, parties may cease to comply with it at any stage, with no formal step required, subject in certain circumstances to the cost consequences. And we say that Haven and the RTA claimants elected in this case to operate outside the protocol or to cease compliance with the protocol in reaching a direct settlement, as they were perfectly able to do. Thirdly, we say that even if there were binding force to the protocol, that would not give the RTA claimants, let alone Edmondson, an entitlement to costs. We say not until the case had settled, but certainly not until stage 1 costs fell due. Fourthly, we say there simply was no normal course of events. Then fifthly, we say that any entitlement to costs would be that of the RTA claimants and not of Edmondson. And finally, sixthly, a subrogated claim by Edmondson, under its right to sue in the client's names, could not give a better claim to costs to Edmondson than the RTA claimants themselves would have had, and that such a subrogated claim would be subject to all the defences which Haven might have been able to run to a claim by the RTA claimants. So turning to what we say as the first law, the acknowledgement of the CNF, we say it's far from amounting to an agreement to be bound by the terms of the protocol. Returning the acknowledgement, in fact, means nothing, and that Edmondson invests it with a significance that it simply does not bear. If I can invite you to look at the protocol, starting at MS page 1252, Stage 1, paragraph 6.1 to 6.6 and 6.7 set out the requirements for the claim notification from the CNF. 6.8 and 9 deal with inadequate information in the CNF, and 6.10 is the crucial paragraph upon which Edmondson relies, giving contractual force to the protocol. The defendant must send to the claimant an electronic acknowledgement the next day after receipt of the CNF. Edmondson attempts to spell out of that acknowledgement, and in each case there was an acknowledgement sent in time in these cases, an undertaking to be bound by the terms of the protocol, but we say the acknowledgement amounts to no such thing. And on its face, all it does is accept that the CNF has been sent and received, and it's an electronic receipt for that document, and nothing more can be read into it than that. My lady, it's important in this regard to note that the protocol is not mandatory. At page 1249, in the preamble at 2.1, this protocol describes the behaviour the court will normally expect of the parties prior to the start of proceedings where a claimant claims damages valued at no more than £10,000 as a result of a personal injury sustained by that person in a road traffic accident. The behaviour the court will normally expect. And if I could invite you to look at page 1084, paragraph 5 of the Statement of Facts and Issues. Although the use of the protocol procedure is not compulsory in the sense that there is no judicial sanction if it is not followed, a claimant who fails to follow the protocol may have his or her legal costs limited to those recoverable under the protocol by the relevant provisions of the civil procedure rules in CPR 45. In practice, the vast majority of qualifying claims are notified and settled in accordance with the provisions of the protocol. Edmondson accepts in its written case, the reference is paragraph 70.1, that the regime laid down in the protocol is not mandatory and points out that this is common ground. But Edmondson goes on to say that a defendant insurer has a choice whether to adhere to the terms of the protocol and that the fact that the regime is not mandatory lends significance to the deliberate choice which the insurer makes. So the issue on that is as to whether merely sending electronically a receipt of a document to say you've got it can amount to a deliberate choice that you will thereafter comply with the protocol and be bound to do it. Because Edmondson's submission assumes a binary choice between acknowledging receipt of the CNF and they say thereby agreeing to adhere to the protocol in every particular on a compulsory basis, or simply not acknowledging it in the first place and dealing with the claim independently of the protocol. And our simple submission is that there is nothing, either in the protocol or elsewhere, to justify that assumption. It's not in any sense equivalent to acknowledging service of proceedings and thereby submitting to the jurisdiction. And we say that simply because there are no proceedings and there is no jurisdiction. The protocol is simply a pre-action way of securing a settlement of a potential dispute, no more and no less. It's a non-mandatory set of arrangements for handling a dispute before issue of proceedings. Before leaving that argument, may I just turn to the Law Society's submissions. At paragraph 6 of the intervener's case, which is at MS 1185, the Law Society argues that in using the protocol and claims portal, Haven was entering into what it calls a tripartite agreement with the RTA claimants and Edmondson, which involved an obligation to pay the fixed costs if and when the protocol stated they were due. And the Law Society seems to be saying that this arose at least in part from the definition of authorised user of the protocol and some of the general conditions of use for portal users. My lady, we don't need to trouble you with the detail of those, but we do not accept that using the portal imposed on Haven any of the contractual obligations, any contractual obligations to Edmondson. If there were any contractual obligations arising under those general conditions, they were owed not to Edmondson, but to RTA Portal Company Limited, which is the portal provider. And furthermore, there is nothing but nothing in those conditions which gives mandatory contractual force to any of the provisions of the protocol. My lady, coming to what we say is the second flaw in Edmondson's analysis and that of the Court of Appeal, it is this, that the Edmondson and the Court of Appeal, we say, failed to recognise that because the protocol is non-mandatory, the parties may cease compliance with it at any stage, and that is what Haven and the RTA claimants did, and that is the only sensible interpretation to put on the two parties' behaviour. We've developed our submission as to why the offers made by Haven were necessarily outside the protocol in our written case at paragraphs 74 to 78, which is page 1117 to 18. But I would please turn to paragraph 32 of the Court of Appeal's judgment briefly once again, which is at 1228. Because it's to be noted that, starting on the fourth line, the Court of Appeal agreed with my submission that a client may dismiss his lawyers, continuing in person, compromise his claim for costs, and take payment of the agreed sum himself. And that it was therefore open to Haven to enter into compromise agreements with the claimants outside the protocol process. And indeed, that's not disputed by Edmondson. At that stage, we say that Haven and the RTA claimants voluntarily and in agreement with each other ceased to comply with the protocol. And we submit that it is completely artificial to interpret the circumstances then pertaining as meaning that they were still within the protocol or acting under the protocol when Haven and the RTA claimants came to a compromise. Because that compromise was plainly and on its face inconsistent with both the procedures and the rules of the protocol, and neither party intended to be bound by it. We also say, following such a settlement, Haven could never have been ordered to pay the settlement monies to Edmondson under any concept of a lien, or risk being ordered to pay twice, because there'd been direct settlements between the parties. Haven couldn't have been required to pay the settlement money to anybody other than the RTA claimants. And the reason for that is that no entitlement in Edmondson to claim payment would ever have arisen. Now, the Court of Appeal went on to say that, as a matter of fact, the claims had not exited the protocol process. And they said, contrary to Lord Marx's submission, the fact that the terms of the compromise agreements were inconsistent with the protocol scheme, which they undoubtedly were, did not have the effect of removing the claims from that scheme. In each case, Haven acted with the intention of defeating Edmondson's entitlement under the scheme, of which Haven had notice at a time when the claim remained within the scheme. And that runs counter to our submission, because we say the claim simply didn't remain within the scheme, because the scheme simply didn't operate like that. There was an entitlement to leave it by agreement. So certainly the Court of Appeal were right to the extent that the CNF had been served, and the right also that the 15 days to serve the insurer's response had not expired. But the Court of Appeal then held that it followed the claim was still continuing within the protocol. And we say, in dealing directly between the parties, they demonstrated a choice not to comply with it. And it's our submission that the Court of Appeal's analysis treats the protocol process as some kind of box which, once entered, exercises a kind of absolute control of the parties' behaviour until such time as they leave the box or exit the protocol. And we submit that doesn't reflect either the reality of the words or of the circumstances of the protocol. And we say that also follows, as I'll now turn to the requirements of the protocol, from those requirements that follow from acknowledgement of the CNF. If I can take you back to 6.11 of the protocol at 1253, the defendant must complete the insurer response section of the CNF, called the CNF response, and send it to the claimant within 15 days. And if I can then ask you to look at 615 to see what happens if the insurer does not do that. The claim will no longer continue under this protocol where the defendant, within the period in paragraph 611 or 613, and we're here concerned with 611, which is the 15 days, 1, makes an admission of liability but alleges contributory negligence other than in relation to the claimant's admitted failure to wear a seatbelt. So, if there's a substantive contrib allegation, the claim drops out of the protocol. 2, does not complete and send the CNF response. That is crucial because if the insurer does nothing, doesn't send out the response, the claim no longer continues under the protocol. If the insurer does not admit liability is 3. 4, notifies the claimant that the defendant considers that there's inadequate mandatory information in the CNF. That's a reference back to the passages I showed you about inadequate information at 6.8. Or that if proceedings were issued, the small claims track would be the normal track for that claim. And the court will remember that this protocol applies to claims at this stage between £1,000 and £10,000, small claims tracks below £1,000. So if the defendant says, no, this is a £500 claim, notifies you, then another reason for the claim not continuing under the protocol. So to summarize, if Haven returns the acknowledgement and does nothing, 15 days, the claim is outside the protocol. If Haven considers the claim's worth less than £1,000 and says so, the same result. The claim only remains within the protocol if claimant admits liability, subject to no substantive contributory negligence allegation, and the claim is considered worth more than £1,000. So that in practice, the insurer has to do nothing, and if he does nothing, it drops out of the protocol.
15 days later.
15 days later, yes. 15 days later anyway. We say that there is nothing to restrict the parties agreeing, impliedly or expressly, that the claim is no longer continuing under the protocol, and that is exactly what happened in this case.
So if the claim had gone on for a bit in the protocol, but for one reason or another, it no longer continued under it, under
Yes.
615, whereupon the claimants, with the help of Edmondson's, filed proceedings and won and got costs which were paid to Edmondson.
Yes.
Would Edmondson have been entitled to hold on to those costs?
Yes.
But your analysis of the client care letter is that there is no obligation
No, if they
on the claimants to pay costs, and so no lien operates.
We're going back now to what I would describe as the successful reconciliation of Lord Briggs' point.
Well, I'm sorry, it may be a repetition of Lord Briggs's question.
I'm not
And
criticising.
if it is, I apologise.
It's
But
Lord Briggs's question coupled with your answer, finessed with my gloss on it, if I may put it that way. I accept that once a right to costs has arisen, Lord Briggs's analysis leads inevitably to the result that at that stage, costs are payable by the defendant to the claimants, the solicitor is entitled to those costs under the client care letter, and at that stage, a fund comes into being over which a lien can be exercised, and the lien can then be exercised. There is no lien prior to that because there is no right to recover costs, and there is no fund. Lord Wilson's point, to me, was to analyse Lord Briggs's point with my submissions, to say, well, once costs are recovered, there is a lien. And I accept that, provided you adhere rigidly to your qualification, once costs are recovered. Because the lien can only arise at the stage that there is costs recovery. So on the analysis that Lord Wilson has just put to me, plainly, if the case falls out of the protocol, for whatever reason, the claimant takes proceedings in the ordinary way, recovers an order for costs, we're in the position of any other personal injury litigation where the solicitor has a lien over the costs recovered. But the converse of that is that if the claim drops out of the protocol, there will be no costs recovery unless the claimant succeeds in securing an order for costs as a result of proceedings. We say that as a matter of construction and of the rules, it's significant that all those rules which deal with leaving the protocol provide simply that the claim will no longer continue under this protocol. So there's nothing either temporal or restrictive about it. The rules concerned are 615, 619, 732 and 766. And they are therefore a set of arrangements to which you adhere, but there are certain circumstances which are provided for where it drops out. That doesn't mean you can't otherwise drop out. We draw some support from that proposition from page 1272, which is CPR Rule 4536, 1b. This rule applies where the claimant elects not to continue with that process and starts proceedings under Part 7. And it then says that in certain circumstances there are consequences to that election. The point we make on that is that the provision recognises that the claimant has an election not to continue with the process. We say correspondingly the defendant has the same election. That all follows from the fact that the protocol is not mandatory, and a fortiori that the parties may agree that the claim will not continue under the protocol, which they do by conduct and necessary implication, by agreeing a settlement out with the protocol that doesn't have costs consequences. And we say that the agreement in this case is inherently incompatible with continued use of the protocol. I refer to paragraph 74D of our written case. Among other things, we say that the communications for the settlement are not electronic, and communications are required by paragraph 5.1 to be electronic, and in practice through the portal. The reference to that is at page 1250. The end of the last sentence, subject to paragraph 612, where the protocol requires information to be sent to a party, it must be sent electronically, and 612 just refers to the requirement to send the defendant only a CNF to the defendant by first-class post. That's on the next page. We say that the point that no CNF response has been made in accordance with paragraph 611, and yet the parties are settling the case between themselves, is incompatible with the continued use of the protocol. There's been no stage 2 settlement pack in accordance with paragraph 726. The offer that is made by the insurers is not made on consideration of such a pack in accordance with 728 to 30. And if I can invite you to read through to yourselves 728 to 730. That deals with consideration of the settlement pack and for the defendant to make an offer, further negotiation, an extension of the initial consideration period, and a further period at the end of the consideration period. And then we say that the offer does not comply with paragraph 737. Paragraph 737, we say the non-compliance with that paragraph makes it quite clear that this is not an offer within the protocol. The settlement does not come about as a result of an offer with the protocol. The paragraph provides an offer to settle made at any stage by either party will automatically include and cannot exclude 1, the stage 2 fixed costs in Rule 4529, 2, an agreement in principle to pay disbursements. 3, a success fee in accordance with 4531. And we submit that the only sensible inference to be drawn from the fact that this is not an offer that complies with the requirements of 737, and an inference to be drawn not just by an objective observer, but by the parties themselves, because they knew perfectly well, and it's common ground, that this was not an offer that had costs added to it, is that when they settled the case, they were operating outside the protocol. So we say that the Court of Appeal's point, that the claim is not removed from the scheme of the protocol, reflects no more than the fact that the 15-day period following the acknowledgement had not expired. The Court of Appeal accepted that had it done so, the claim would have been removed from the protocol, but seemed to assume that without an automatic removal under the rules, in spite of the fact that the protocol was non-mandatory, there wasn't a way for the parties to agree, as they plainly did in this case, that the claim was no longer proceeding within the protocol. And we say this, if it did make a difference that the claim was continuing under the protocol, that would mean that the availability of equitable intervention in this case would be entirely dependent upon whether or not the 15 days had expired, a point to which I think my Lord Wilson was obliquely referring, because neither Edmondson nor anyone else suggests that if Haven had simply done nothing and the claim had not continued under the protocol in accordance with 615, then there wouldn't have been, nobody suggests there would have been any entitlement, because there plainly wouldn't. And as my Lord Wilson pointed out, it would then be either for the case to settle, as it did in this case privately, or for the claim to proceed under Part 7 with ordinary court proceedings. Finally, and in a way most importantly, we submit that once it's agreed, as it was by the Court of Appeal, that the parties were free to compromise outside the protocol, that is not in accordance with its requirements, it must be contrary to policy to interpret the protocol as imposing on the parties a restriction to the effect that the rules bind them to the payment of costs over and above and in contradiction with any settlement figure that they actually agreed. My lady, the next point is this. The third flaw, and we say a central error in the Court of Appeal's judgment of paragraph 31, is that there is no entitlement to fixed costs in the normal course of events. First, because there's no normal course of events, because starting out on the protocol procedure doesn't give rise to any such entitlement, and that's our written case at 54 to 59. And we say that not only acknowledgement of the CNF gives no contractual obligation, imposes no contractual obligation, nor does it give any legitimate expectation of cost recovery, let alone an entitlement. Which is why I said at the outset of this section of my submissions, the Court of Appeal talk about entitlement. If there wasn't entitlement, not only that, there wasn't even a legitimate expectation, and a legitimate expectation wouldn't be enough. We say that the claimant will only secure any credible expectation of recovering costs at a stage when the CNF is completed and returned, this is under the protocol, in which liability is admitted under 618. Because if that happens, and perhaps I can take you to 618, page 1254. Except where the claimant is a child, the defendant must pay the stage 1 fixed costs in Rule 4529, where liability is admitted, or admitted subject only to a seatbelt contrib, within 10 days after sending the CNF response to the claimant, as provided in paragraph 611 or 13. So 10 days after the CNF response, fixed costs under stage 1 must be paid. But we say, even though there is that rule, there is no sanction for non-payment. So that if you're complying with the requirements of the protocol, and that's the behaviour normally required, it's not a legal obligation, and nor is it an entitlement to have that payment. And while that may be surprising at first blush, it is quite clear from paragraph 619. Where the defendant fails to pay the stage 1 fixed costs within the period specified in paragraph 618, the claimant may give written notice that the claim will no longer continue under this protocol. Unless the claimant's notice is sent to the defendant within 10 days after the expiry of the period in paragraph 618, the claim will continue under this protocol. So
was liability ever admitted?
No, in this
These
case.
claims were settled.
The case is settled, but that
That's
may
not the
reflect,
same as admitting liability.
And in all these cases, it reflects a combination of the defendant's view of liability and the amount the defendant thinks the claimant will get. It may be that there might have been an admission of liability at a later stage, but there's absolutely no question of there being an admission of liability in this case. And it only can proceed under the protocol if there is an admission of liability contained in the CNF response, at which stage the only question is in quantum. Seatbelt control. But my point here is that 619 only provides that non-payment gives the claimant the right to serve notice taking the case outside the protocol, and the corresponding provisions for stage 2 are at 761 on page 1262. Non-settlement payment by the defendant at the end of stage 2, except where the claimant is a child, the defendant must pay to the claimant. Final offer of damages. So there's a ping-pong of damages offers. Final offer has to be paid, less any deductible amount payable to the CRU, the Compensation Recovery Unit, and previous interim payment, which is payable under the rules. Any unpaid fixed costs, stage 1 fixed costs in Rule 4529, so that allows for the previous non-payment. The stage 2 fixed costs in 4529, and the disbursements in 4532 that have been agreed. And then 763 makes an exactly parallel provision for non-payment, which doesn't, 766, but you need to leave 762 and 763 as well, actually. A parallel provision for non-payment in 766, which is not a sanction. It's just that you can serve notice as a claimant that the claim will no longer continue under the protocol. So 766, where the defendant doesn't comply with 763 or 765, claimant may give written notice the claim will no longer continue under the protocol and start proceedings under Part 7. 763 is subject to 764 and 765. Defendant must pay the amounts in 761 and 762 within 15 days of receiving the court proceedings pack with which we've looked from the claimant. And 765 is a fresh CRU certificate. So again, no compulsion. And if the claim does drop out of the protocol, it proceeds under the pre-action protocol for PI claims, and the CNF has effect as a letter of claim, provided the information in it is adequate. Now, Edmondson relies in its written case on the aim of the protocol set out in paragraph 3.1 as ensuring that the claimant's legal representative receives the fixed cost at the end of each stage of the protocol. 3.1 is at 1249. And it's certainly, that's what it says. At 3. But first of all, the stated aim of the protocol is itself not mandatory. It can't give Edmondson an entitlement to costs recovery. In any event, the aim is for payment at the end of each stage in this protocol. It's not to ensure that a solicitor can achieve a right to payment simply by issuing a CNF, because the end of of stage 1 is, or was at this stage, after the insurer response and an admission of liability. Edmondson also relies on 737 of the protocol to build a case on entitlement to costs that is independent of the normal course of events that we say the Court of Appeal relied on. And we say it is plain from the terms of the protocol that paragraph 737, which we've looked at, applies only to offers made within and in accordance with the protocol procedure. May I invite you to look again at 737? Which is at page 1258. We say first that the reference to stage 2 costs alone, no reference to stage 1 costs, is only consistent to an offer made within the protocol scheme. The very fact that the provision applies only to stage 2 costs demonstrates an assumption that stage 1 costs have already been paid. Stage 1 costs are payable under 618 within 10 days after the CNF response where liability is admitted. So 737 presupposes compliance with the protocol all the way up to the offer stage. And we say that if the case doesn't proceed within the protocol after the CNF acknowledgement, then there's no CNF response and the payment of stage 1 costs never arises. We say the words "at any stage" taken in context at the beginning of 737 plainly refer to the stages of the protocol. We also submit that the reference within 737 to any offer to settle made at any stage by either party, rather than to any settlement, is only a reference to the offer. And that is plainly, we submit, a reference to an offer made under paragraph 728 during the consideration period. And when it says by either party, that of course can encompass offers made under 731 including counter-offers.
Is that consistent with at any stage?
Well, it is.
But otherwise, it's a bit of a. I mean, bearing in mind all of this is designed to encourage. Bearing in mind that all of this is designed to encourage parties to settle these very small claims with the minimum incurral of costs.
Yes.
It's otherwise quite odd to see nothing about a settlement made before you ever get to stage 2. So that one's almost sort of thinking, hold on a minute, there's nothing here yet about what happens if there's a settlement, for example, before the 15-day CNF is sent in, not just the acknowledgement, but the full response. And one then sees any offer to settle at any stage appears on the face of it to fill that gap.
The words at any stage could be taken to refer to that, to any stage at large. But we say you have to look at it in context.
I am.
And the context, I'm sorry, I don't wish to be cheeky, but the context, we say, is a relatively rigid set of procedures and stages. The CNF, the acknowledgement, the insurer response, followed by the settlement pack, and then the scheme of offers.
Well, Lord Marks, we've got to 1 o'clock.
My lady, we have. And
Yes.
you may have noticed
Going
my
by
voice
the
is
clock
starting
on my machine, which is the one I go by.
my voice was
because
starting
that
to
is
give
what-
out, so we'll
Yes.
appreciate it.
It seems to me that you're getting fairly close to the end of your submissions.
I wouldn't put it as highly as that.
Well.
I almost dare to say I'm exactly where I expected to be by lunchtime.
Yes, it did occur to us that 4 hours each side was really quite generous in the context of this.
My lady, I see that. At the time we set the timetable, and I still actually think we were right to do so, we were both very mindful of the fact that in the Court of Appeal we only got as far as notice in 1 whole day. It was a fairly discursive hearing, except. But
Well, it hasn't been a discursive hearing this time, so
certainly.
something significantly less than 4 hours might be appropriate.
Well, my lady, I will.
You've heard him say that.
I did.
Yes. But we will look forward to hearing from you further at 2 o'clock.
Thank you very much.
We will adjourn now.